Stories that you're going to hear today, you'll get some sense of how risky it can be for a judge to stand up in front of people and talk in this neck of the woods. And one of the risks is hardly ever that you're going to fall down on a moving bus and break your neck. And so I'm trying to accommodate, understand that new risk to me as I share with you all a few interesting facts about mostly about what happened with Briggs versus Elliott, but I do want to go back a little bit, and Mr. Felder, I'll just sort of steal some of your thunder there and talk about a couple of these little moments that you mentioned. But you know, it's the thing about Thurgood Marshall's mouth hanging open when Judge Waring ruled as he did in that teacher pay case is actually a well-documented fact. It's not something that we just tell as part of our stories. You all will remember Juan Williams, who got himself into a national controversy a couple of years ago. He wrote a biography of Thurgood Marshall, and he tells that story in his biography about Thurgood Marshall's mouth hanging open. It always interests me when I think about my perspective on Thurgood Marshall. When I was 4 years old, Thurgood Marshall was sworn into the United States Supreme Court. So when I think of my adult life, to me, Thurgood Marshall is a justice on the United States Supreme Court. And I think that young people my age and older and younger have that same impression initially. And even before that, for 6 years before that, he was a judge on the, I think, the Second Circuit Court of Appeals, and then he was the Solicitor General of the United States. And so we have a tendency to think of him as a justice on the United States Supreme Court, and we lose sight of the fact that in reality, when he sent Robert Carter to Summerton, South Carolina, in 1949, 1950 to try to drum up support to file this lawsuit that became Briggs versus Elliott, he was a national celebrity. And when Thurgood Marshall went to Charleston in 1951 to try Briggs versus Elliott, he had a hard time getting in the front door of the courthouse because the people mobbed him. They just were trying to touch him. He was such a celebrity, and it was only shortly after the trial in that case that Thurgood Marshall's picture first appeared on the cover of Time magazine. It's also very interesting to me how the relationship between Marshall and Waring progressed. And I think that we have a tendency, all of us, to think that when we look at these historical events, like Brown versus Board of Education happening in 1954, declaring that segregated schools were unconstitutional, we have a tendency to think that somehow that was predestined, that it was sort of historically mandated, and it doesn't really matter maybe when it was going to happen, but it was going to happen. But that's not necessarily true, and one of the things that to me is most interesting about Briggs versus Elliott, to start with, am I correct that it was Robert Carter who came to Summerton? Yep. Sometime in, I don't know exactly when that visit would have been. Would it have to have been 49? Okay. And did so, as I understand it, carrying the banner of Thurgood Marshall. And so that the people here were able to sort of understand that they wouldn't be doing this alone. They were going to have this nationally known and respected leader, Thurgood Marshall, to stand with them. The other thing is the friendship that existed between Marshall and Waring. In that time frame, lawsuits were being brought somewhat frequently around the country to deal with the problem of segregated schools, but not one single lawsuit had ever been brought where they claimed that it was unconstitutional to segregate schools. They had sat around, as lawyers wisely do, and strategized, and they had decided that the time was not right to bring a lawsuit alleging that the segregated school system was unconstitutional because they feared they would lose. And when Thurgood Marshall and his co-counsel drafted the complaint in Briggs versus Elliott, they were very careful not to make the allegation in the lawsuit that the segregated schools were unconstitutional, but rather they made the allegation that the schools were unequally funded and therefore they needed to be changed. And it was no surprise to Thurgood Marshall, of course, that when he showed up in Charleston in late 1950 for some pretrial conferences, that Judge Waring said, we've been talking about this for years. You are going to pursue the constitutional challenge. And actually, Juan Williams writes in his biography of Thurgood Marshall, and this is a really strange sequence of events to happen between a lawyer and a judge, but historically we're glad it did. Wadis Waring reviewed Marshall's brief 2 times and rejected it both times because it did not squarely raise the constitutional challenge, and only after it was very clear that Marshall was not going to get out of Charleston without attacking constitutionality of segregation did they then squarely frame the issue. That went on even till after the trial. There was an interesting event that I'll talk about in just a minute when Briggs versus Elliott got to Washington. But then after the trial in Briggs, the Supreme Court remanded the case to South Carolina, the United States Supreme Court did, to address the funding question. And by that time, Judge Waring had decided that he was out of the case, and he refused to participate in that remand because all he wanted to talk about was the constitutionality of segregation. It had become, it's interesting that you say he made these decisions out of the motivation of retaliation for his mistreatment by the Charleston Society and Charleston Bar for what he did, they perceived, to his wife, and that's what I've always heard too. But it's an interesting theory about what sort of freed him to follow his conscience to make these decisions. But so understanding that the Briggs case was the first time that the constitutional challenge had ever been made, it really sheds a little light, I think, on the significance of Briggs. In other words, Briggs is not really just one of the 5 cases. Briggs is the case. If it hadn't been for Briggs, Brown versus Board of Education would not have happened in 1954. And I think that can be understood to have resulted, of course, from Thurgood Marshall, of course from the Briggs family and the other families in Somerton, procedure in federal court that is no longer around, that once a constitutional challenge of that type was made against a state, that instead of a case being decided by one judge, it went before a 3-judge panel. So as soon as Judge Waring successfully convinced Thurgood Marshall to raise the constitutional question, it became a 3-judge panel. Interestingly, back in that day, South Carolina was divided into 2 federal districts. This was the Eastern District where Judge Waring was. There was a federal judge in the Western District, and everybody knew where Judge Waring stood on the question, and everybody knew where Judge George Bell Timmerman from the Western District stood on the question. They needed a 3rd judge, and the 4th Circuit, I suppose, or maybe the Supreme Court, appointed a judge named Parker from North Carolina, and everybody was slightly uncertain about what his position was, although everybody sort of figured that Waring probably was the only judge in the country who believed that it was unconstitutional. So when they tried the case, a funny little story about that uncertainty, I think Thurgood Marshall was so sure that they were going to lose before the 3-judge panel that they said they were not going to file a post-trial brief. They were done. As soon as the case was tried, they were ready to go back and get to work on some other cases and get ready for their trip to Washington. And the judges said, well, Mr. Marshall, aren't you going to file a brief? And when he said no, Judge Parker from North Carolina said, you mean to tell me you're going to pursue this big issue, you're not even going to file a brief? And Mr. Marshall then thinks to himself, aha, maybe he actually is listening. And so they went back and prepared a brief only to realize what they had initially suspected, which was no, the Judge Parker was not listening. Judge Waring was prepared to write a dissent. And so this atmosphere that existed not only here in South Carolina but everywhere against people, this theme of violence against people anybody who wanted to stand up to the status quo, not only was something that the families here in Somerton had to deal with, it was something that Judge Waring had to deal with. After the trial, he received a threat that he and his wife thought was of such significance that he actually took a copy of his dissent before it was ready to be filed and secured it in the federal courthouse in case he got killed, so that if that happened, his dissent could still be filed. And I'm not a great student on the exact composition of the Supreme Court's opinion in Brown versus Board of Education, but many legal historians have written that Justice Warren's opinion in that case was based on the dissent that was written by Wadis Waring in Briggs versus Elliott, and that it tracks it with logically. So very interesting involvement that South Carolina has had in how Brown versus Board of Education happened. Briggs versus Elliott is also the reason we have a sales tax in South Carolina. And so after the trial, the South Carolina legislature passed a law to equally fund black schools. That was while the case was on appeal to the U.S. Supreme Court. And so in light of that, the U.S. Supreme Court remanded the case to South Carolina for hearings to determine whether or not this funding change would change the outcome of the case. So thank you to that case for us having a sales tax. I'm going to just say a couple of more things about what I think that Briggs versus Elliott and Thurgood Marshall and Waiters Waring meant to us then and mean to us now. And I am going to kind of summarize some of that when we get over to the church in a few minutes. But you mentioned Elmore versus Rice, which was the case involving the Democratic voting system in the primary, where they did not allow blacks to vote in the primary. And you also mentioned Wrighton versus the University of South Carolina, cases Judge Waring decided. And interestingly, Judge Matthew Perry, who was not even a lawyer yet at that time, was in the courtroom when both of those cases were tried. And I always found that to be fascinating, and it leads me to feel that what they did carries on with us. It leads us, it inspires us, and even to this day does that. It certainly did to Matthew Perry. After Elmore versus Rice, Matthew Perry actually went door to door around South Carolina trying to drum up support in the black communities to go and vote in the first ever Democratic primary. And then you mentioned, of course, that Judge Perry was a law student in the second class at the South Carolina State Law School. So those are the, let me see if I have anything. What I was trying to do was just come up with some of the interesting sort of little known facts about Briggs versus Elliott that you all might find entertaining. I'll be happy to take any questions if you all want to ask anything about what I've been talking about, and I'll get another chance to talk to you again in just a few minutes. Yes?
My question is regarding the judge sort of influencing sort of the theory of the case for Thurgood Marshall to pursue. Was there ever an allegation of a predisposition of the judge at that time, or were there bar rules that sort of affected that? I mean, could you see that happening today, or is it just because of the constitutional nature that was being raised? Does that change it some?
Well, I'll repeat the question, and it's whether or not there was ever any allegation that Judge Waring was predisposed to rule a certain way in Briggs versus Elliott. You know, I don't really know of anything that was ever officially done. One of the things that's true about federal judges is that once you become a federal judge, there's really not anything that anybody can do to you. You're sort of there. And also, I don't think there was any doubt about Judge Waring's predisposition. And in fact, anticipating in the wake of the equal teacher pay case, in the wake of Elmore versus Rice and Wrighton versus the University of South Carolina, and in anticipation of ultimately a challenge to segregated schools, the political system was trying to get rid of Judge Waring. Two of our congressmen, Mendel Rivers, who was the congressman from what is now the 1st District here, and my old congressman, Brian Dorn from up in the upstate, circulated petitions around South Carolina and had 20,000 signatures on petitions to have Judge Waring impeached. So I don't think there was really any doubt where Judge Waring stood on the question. How did he go about doing it? So, you know, you mentioned an ethical issue, and in modern times, I'm a judge, been a judge for 13 years. It is absolutely unheard of, well, I hope, that I might sit down at dinner during the trial at my house with one of the lawyers to talk about the case. And yet that's exactly what happened in Briggs versus Elliott. Y'all are headed to Charleston soon. I was disappointed to hear that y'all are not going to be able to go right downtown. I think you're headed somewhere else, but about 2 doors from the federal courthouse on Meeting Street in Charleston, house number 61, is where Judge Waring lived. And during the trial, Thurgood Marshall came over to dinner. And as Juan Williams writes, Judge Waring said, listen, it's time for you to make history by making law. That's what he said. It's time for you to make history by making law, convincing him that he had to raise this and pursue this constitutional challenge. So in modern ethical terms, that conversation would be impermissible. When we look at the signature moments of the history of the United States, maybe we overlook minor details like that. Yes, ma'am?
Explain how, if Briggs was really the case, how the case actually became to be known as Brown v. Board.
Okay, I'll try. Mr. Felder may know better than me, but the question is, if I say Briggs is the case, why is it called Brown versus Board of Education? And I think that there are two theories about that. One of the theories is that the Supreme Court consciously decided that they wanted the case to appear to be of national significance and not just a retaliatory move against the southern states. That's one theory. The other theory is that it was the necessary practical result of the Briggs case being remanded to South Carolina for a determination of whether this funding legislation that the South Carolina General Assembly had passed would solve the problem, resulted in the lead case, in other words, the first case on the docket no longer being Briggs. By the time Briggs got back to Washington, Brown and some of the other cases were ahead of it in order. I don't know. Do you have a theory on which one is?
That theory.
The second one?
The second one,
yeah. But, you know, it's like anything else. They may have said, we don't want this to have just Southern significance. Let's come up with a legitimate reason not to call it Briggs versus Elliott. So who knows? Yes, ma'am?
We've been reading two books, one by Rosenberg and one by Carmen, discussing the historical effect of Brown versus Board of Education, and we've really been discussing this as a group. And there's some theory or aspects that alleges that it really was not as big, and this is also for Mr. Feldman, this question, that it was almost predisposed, that if it wasn't going to be this case, it was going to be something else because the civil rights movement was already in motion and that this was coming. And it's clear from today, particularly here, that this case was just such a big pivotal case in the mind of South Carolina, at least, whereas we're reading where maybe it wasn't as big in the whole scheme of civil rights. Can both of you speak to that? Did that do what you?
Now, you must remember Brown overturned Plessy versus Ferguson, which was the law for 60 years up until that time. So you cannot say it was not a big deal. That overturned Plessy, and then the civil rights movement really began after the Brown case.
Go ahead.
Okay. One other little note on the Brown case and Justice Earl Warren. You know, Warren had been governor of California, Republican, appointed by Eisenhower. After the Brown decision, it is alleged that Eisenhower said that was the damnedest appointment I ever made, making Warren Chief Justice of the Supreme Court, because of what he had done in rounding up on a unanimous decision in the Brown case. Yeah.
Any other questions? Yes, ma'am?
Yeah, this is your current day. You are a judge. You've seen a lot of cases. Is there anything percolating or coming through the courts today that has a great significance on civil rights or that you're grappling with now?
Well, so the question is, what's our big issue? What's our big societal issue of the modern day when it comes to law? Is there anything of the significance on the level of the end of segregated schools in my court? Well, this week I worked on a very significant case involving whether or not the Administrative Law Court had properly explained itself in ruling that a unemployed worker had not mailed his appeal notice on time. So I don't think so, really. I mean, it's, we're not even to Sumter yet, are we?
No, we're about 20 miles from Sumter.
So are we? I might just go ahead and make my little argument because it kind of fits. It kind of fits right here. So, I will. Let me answer that question. I spent a lot of time as a judge speaking to lawyers, and I try to understand for myself and also to explain to other lawyers what it means to be a lawyer. Why does society even have us? And when you think about the civil rights era and you think about Briggs versus Elliott and you look at Thurgood Marshall and some of the other lawyers who did what they did, well, that's pretty easy to understand why we had Thurgood Marshall. But why do we have Little John Few? Or why do we have some of the other, why do we allow people to have the status that lawyers have? And so I think it's something that warrants some thought. And when I think about that, I kind of go back and think about several key people. And two of them are Thurgood Marshall and Waydis Waring. But before them, I like to think about Frederick Douglass. And Frederick Douglass, of course, was not a lawyer. Frederick Douglass had absolutely nothing personally to do with Briggs versus Elliott or with Brown versus Board of Education. In fact, Frederick Douglass died 8 years before Thurgood Marshall was even born. And so in that sense, Thurgood Marshall never knew Frederick Douglass. You all know who Frederick Douglass is. He was a brilliant slave who arranged his own freedom by the time he was age 27. He wrote his autobiography, a narrative of the life of Frederick Douglass, that was reprinted in 3 different languages around the world, and by the time of his death had been printed over 11,000 times. He was the ambassador, basically the ambassador to Haiti. He ran for vice president of the United States. He traveled all over the world speaking against slavery and became a truly well listened to advocate, not only against slavery, but also in favor of other human rights. It's very interesting to me, and certainly coincidental, that Thurgood Marshall's high school's name was Frederick Douglass High School. That's a coincidence, I'm sure, but it's not a coincidence that on Marshall's desk at the Supreme Court, he kept a statue of Frederick Douglass. And then I think about how Waydis Waring and Thurgood Marshall influenced each other. And so I talked a minute ago about Thurgood Marshall and how by the time he came to South Carolina in the late 1940s, he was already very famous. Same for Waydis Waring. Today, nobody even knows who Waydis Waring is. I will go to lawyers' meetings and I will say, who knows who Waydis Waring is? And hardly anybody will raise their hand. That's beginning to change, as I will explain in just a few minutes. But in 1948, he was nationally known. There was an article in Time magazine in 1948 entitled "The Man They Love to Hate." That was the name of the article, and it was written about Waydis Waring. And it was based primarily on the decisions that Mr. Felder described earlier. He had been criticized and he had been praised in newspaper columns all over the country in the 1940s. He was a well-known figure who was in the centerpiece of the American consciousness back in that time frame. These two people had a great influence on each other, Waydis Waring and Thurgood Marshall. And then I think about Matthew Perry being in the courtroom when those cases were tried, and when Elmore versus Rice, which was the Democratic voting case, and also the Wrighton case, which was the availability of law school to black men and women. When I think about the fact that he was in that courtroom and watched those cases being tried, and then after having seen what he saw, went out and personally worked to make the implementation of those rights a reality, that is an amazing thing to me. And then I think, what did Matthew Perry do later? Several years ago, I gave this a speech to a bunch of lawyers that is basically on this subject. And I remember walking into the room early in the morning. There were going to be about 200 lawyers in the room, and I was scared to death. I mean, this crowd right here seems to me to be a very scary crowd just at your size, but 200 lawyers in there, I was about to die. I was so scared. And as I was walking by, there was a small group of people talking, and I could hear them saying that Judge Perry was going to be their guest at their next meeting. And I kind of remember smiling to myself thinking, well, I'm going to teach y'all a little bit about Judge Perry here in a few minutes. Well, when they heard that, they then asked me if I could come and introduce Judge Perry when they had him at their meeting. And so I said, I'll do it, but I'm not going to just stand up there and say that he was born at this date and he went to this school. If you want me to do it, I need 15 minutes. And they said, okay. So, understanding that everybody in the audience on that day knew they weren't there to hear me, they were here to hear Judge Perry, I confined my remarks to 14 minutes. But I told the story about Judge Perry being in the courtroom and all that, and I also mentioned Frederick Douglass. And it'll seem a little weird for me to claim that I was able to sort of touch Judge Perry like that, but when he got up and started speaking, he spent the first 5 minutes talking about Frederick Douglass and talking about how important Frederick Douglass had been in Thurgood Marshall's life and in his life, and encouraging everybody in that room to go out and Judge Perry's, and y'all don't really know him, but he was a giant of a man. And not only was he tall, he was bigger than me, but he had a giant voice. When he spoke, he would not need this microphone. His voice would just boom all the way to the back of the bus. And he was also, of course, a giant in the work that he did. Many of the most important civil rights cases on up into the 60s were handled by Judge Perry coming out of South Carolina. But he recommended that everybody in the room go and purchase a biography of Frederick Douglass. And were you going to add something?
No.
Oh. So, and then what I do is I try to kind of tell a story about it and make an argument of their relevance to us today. And as a part of that story, I mentioned a well-known judge here in South Carolina named Frank Epps. And if those of you who are from South Carolina will know who he is. He was a judge here for many, many, many years, well-known, traveled all over the state. One of the things about him that everybody remembers is that he knew everybody in the state. And there's stories about him sitting in a trial, and he would look over and see a juror, and he would say, what's your last name? Your head looks funny, and I can tell by the shape of your head that you're a Simpson from over in the community next door. And they would go, that's right, Judge, I don't know how you knew that. He had an amazing ability with people like that. But so when Briggs was being tried in 1951, the government of South Carolina was watching that case very carefully. And of course, I've already spoke about the legislation to refund all of the black schools. The legislature was watching the case very carefully. Frank Epps was a freshman member of the South Carolina House of Representatives in 1951 when all that was going on. And so I make the argument that what Thurgood Marshall and Watus Waring did shaped the life of Frank Epps. And then I would go on and tell a story about a case that happened in my court where a young lawyer against popular tide stood up and did something courageous to defend the rights of a litigant there in the courtroom. And when I give this talk to South Carolina lawyers, they all, of course, know that Frank Epps has been dead for 10 years. And I tell them that the lawyer who did it was Frank Epps. And most of them immediately figured out that I'm talking about his son, Frank Epps Jr. And so the idea being that what happened in Briggs, just like in so many other important historical events, when we see courageous people step up, what happened in Briggs continues to trickle down to us today. And so that's a real indirect connection. I'm trying to argue this is a stupid argument, right? There's this lawyer doing something courageous in my courtroom in 2007, and I'm trying to argue that he did that because of Thurgood Marshall coming to South Carolina in 1950. So I now can go about it a little more directly. And trace it direct. Those of us who know Judge Perry know that that Thurgood Marshall was definitely his mentor and one of the people he studied under and looked up to and was a great influence on him. It turns out that Judge Epps had the same relationship with Matthew Perry. So there is a sort of a direct connection and a somewhat credible argument that we can make that what these people did, the courage that these people showed, plays itself out in what we do, plays itself out in why you all chose to go to school and then come to South Carolina to learn. And I'm gonna, if I can just take about one more, you got it. We don't take
8 minutes out.
I'm gonna take 2 more minutes.
Save me 5 minutes.
Oh, save you 5?
Save me 5 minutes.
Okay. Well, I'll just I'll wrap it up then and say that thank you for letting me try to make that point to you, and just say that when I think about what Frederick Douglass must have thought to himself when he was having his life beat out of him by the new masters that he would be sent to for challenging the status quo. When I think about what Thurgood Marshall must have thought about when he was facing the challenges that he faced, when I think about what Waydis Waring must have thought about when he was being kicked out of his home city because he stood up for what was right, I think that they must have turned their focus to us. They must have looked forward in time and thought to themselves that if I do the right thing and demonstrate it to the people who follow them. And so I would just say that the way I look at that is that I feel like their legacy is in my hands. And if they are to have successfully demonstrated to us what they meant to show us, then I better get to work. And so I really appreciate the opportunity for you all to let me come and speak.
Okay.